Okay, good morning, everybody. We'll call this hearing to order. And I know we have at least one preliminary matter. Mr. Elliott.
Mr. Chairman, thank you very briefly. Through this witness, I introduced yesterday the design and construction agreement between South Carolina Public Service Authority and South Carolina Electric and Gas Company for Virgil C. Summer Nuclear Station Units 2 and 3, dated as of October 20, 2011. The copy I was working with was my file copy and has some highlighting on it, which the Commission may recall. I thought it was in everybody's best interest if I asked to substitute a clean copy for that which was in the record. I've consulted with Mr. Balser and I've consulted with Judge Baxley. I kind of presume the other parties would not mind, and there's no objection. I would note that there are some slight dissimilarities. There's a map in the copy I'm substituting that was not relevant to my inquiry, and the notations are different, but they are in all other respects identical. So if I may move to substitute a clean copy for the existing exhibit. What's the number, Ms. Weed? I'm sorry. 19? 19.
Okay,
19, yes.
we will substitute that copy on exhibit number 19.
Please, and Ms. Weed has got the documents in question and will handle it for us. Thank you.
Okay, thank you.
Sorry to interrupt.
It's okay. Any other preliminary matters that we need to do? Mr. Butler.
Yes, sir. Thank you, Mr. Chairman. I just had one preliminary announcement. On some of the matters that were once confidential but are now public, we would ask, if possible, that you furnish copies to Ms. Wheat of any newly public information. This would help the court reporters greatly in having a fair transcript of this proceeding. Thank you very much. Thank you, Mr. Chairman.
All right, now, so we resume with Mr. Jones still under oath. And Mr. Challey, it's your mic.
Thank you, Mr. Chairman. Mr. Jones, when we broke, do you recall the instruction to you not to discuss your testimony while we were on break?
Yes.
Okay. Did you talk to any ORS lawyers since we closed the hearing on Friday?
I did talk to lawyers, but not about my testimony, sir.
Okay. Did you talk to any ORS representatives about your testimony?
I did not talk to anyone about my testimony.
Okay, great. Now, when we broke, I was moving on from Bechtel to a different topic, but I want to cover a handful of Bechtel issues with you just to round it out. First, your chart over there that I pulled in front of Mr. Willoughby, it indicates that the owners, you believe, the owners agreed to engage an outside expert to conduct an assessment of the project in September of 2014. Isn't that right?
I'm sorry, would you repeat that question?
Yeah, and if you need to refer to your chart, we can have you read precisely from the September 3, 2014 entry. But your chart indicates that you believe the owners agreed to engage an outside expert to conduct an assessment of the project in September of 2014. Isn't that right?
Well, I'd need to see the chart to get the date, but my recollection, if you're talking about when Mr. Marsh agreed for that, yes.
Okay. I do want to be precise on this, so if we need to look at your chart, let's do that. Here, I'll hand it to you.
While we're doing that, Mr. Chairman, I'm not sure of the rights of a witness in this case, and since I was unable to discuss this with my counsel, I have a question that I want to make sure that I understand the legal term that Mr. Chawley used and whether it is in accordance with the same definitions that exist in common usage, and that was his use of the term impeach. I just want to make sure that there's not some legal interpretation of that I don't understand and don't comprehend. If you would ask for some clarification on that.
Turn that over to Mr. Butler.
Okay, I think with counsel for SCENG's permission on something like that, I think he's entitled to talk to his counsel in terms of a definition. Anyone have any comment?
The purpose of impeachment, as I used it on Friday, and as I'm sure we'll be using with witnesses throughout the hearing, is to, I would argue, discredit or call into question certain of the assumptions that the witness is relying on. I don't think Mr. Jones needs counsel on that. This is just a routine evidentiary matter. It means nothing more than that.
Does ORS have any objection to that explanation? Objection. All right, thank you.
Thank you very much. Yes, that is in reference to the email from Mr. Marsh to Mr. Carter, where Mr. Marsh agreed that they were going to engage an outside party, outside expert.
Okay. So I want to make sure we've said precisely what's on your chart for that entry. Can you read what you've got for September 3, 2014? It's in black.
Okay. Marsh email to Carter, ready to engage outside expert to audit. Oh, I'm sorry. Assist. Sorry, I couldn't see that. With project schedule and status review.
So you understand there was a September 3 email between Marsh and Carter regarding hiring an outside expert, right?
I don't understand that, sir. There was a written evidence of that.
Have you ever looked at the email you're citing?
Yes.
Let's look at it here on the screen. This is tab 18, Dan. Yeah, Mitch, we're done with the chart. Thank you, sir. Mr. Jones, I've handed you an email exchange between Lonnie Carter and Kevin Marsh that is has two dates on it. Email from Kevin Marsh to Lonnie Carter, which is the first in the chain, is dated September 3, 2014. You see that?
Yes.
And then Mr. Carter follows up on that email, responds to Mr. Marsh on September 8, right? Very first page.
Yes.
Okay, so this is the email you're referring to?
Yes.
Okay, Mr. Jones, this email says nothing at all about hiring an outside consultant, does it?
If you believe that the statement, we are ready to move forward with hiring, engaging an additional resource with significant construction experience to assist us with evaluating the construction schedule and project status, if you said it doesn't say anything about that, I would disagree with that.
You put on your chart that September 3, 2014 indicates Mr. Marsh agreed to hire an outside consultant to assess the project, and this email says nothing of that sort, does it?
No, I totally disagree with that.
Let's look at Mr. Marsh's email. It says, we are ready to move forward with hiring/engaging an additional resource with significant construction expertise to assist us with evaluating the construction schedule and project status. Read the next sentence, please, Mr. Jones.
I believe having this person on our staff versus working as a consultant will avoid conflicts with consortium on proprietary matters. I would recommend that Jeff Archie work with Mike Crosby to help identify potential candidates for this role.
Mr. Marsh is talking about hiring a person, isn't he? Not an outside consultant.
What is an outside consultant, sir?
He makes very clear that he does not want someone working as a consultant. His agreement here is to hire a person on our staff, right?
I would assume you could interpret it that way, but it doesn't. It also doesn't negate hiring someone from outside. It just says that he would prefer that.
Yes, it does. It says, I believe having this person on our staff versus working as a consultant will avoid conflicts with the consortium on proprietary matters. Mr. Marsh is telling Mr. Carter, I want to hire, if anyone, an individual to be on our staff, isn't he?
That's one interpretation, yes, sir.
And he's not saying anything about hiring an outside consultant to do an assessment of the project, is he?
Again, that's your interpretation.
Okay. Let's look at what Mr. Carter responds to Mr. Marsh with on the very first page of this email. Number 1. Second sentence. I agree that Jeff Archie and Michael Crosby work together to develop a job description and placement for you and I to concur. And it's your testimony before the commission today that this signifies the owner's agreement to hire an outside expert to conduct an assessment of the project?
I think you also need to look at the first line. There's an agreement on moving forward to engage additional resources, which is plural, in construction management.
Okay, and then he continues after the second sentence where he talks about a job description to say this will allow us to better identify potential candidates. He concludes, my thinking is that the first task for this individual will be to determine the scope of the task at hand and the number of personnel resources needed. So they're talking about hiring an individual, not hiring an outside consultant to do an assessment of the project, right?
Again, if you read what it says determine the scope of the task at hand and the number of personnel resources needed. To me, that means they're talking about bringing additional resources on the project to evaluate it.
You've relied on this email and only this email to support your claim that in September of 2014, the owners agreed to hire an outside consultant for the project. And that's just not true.
Your interpretation, sir.
My interpretation and Mr. Marsh's interpretation. Have you read Mr. Marsh's deposition transcript in this case?
Objection, Your Honor. Argument.
Yeah, I would sustain.
Okay. Mr. Jones, have you read Mr. Marsh's deposition transcript in this case?
I have.
Okay. You read the deposition transcript from Mr. Marsh that was conducted last week, a week ago today.
Oh, no, I have not read that one.
What deposition transcript of Mr. Marsh have you read then?
I thought he had a deposition prior to this. Maybe I'm confusing that with
No,
this.
he has not.
Okay, then I did not read his deposition.
Okay, well, we don't have to rely on this email to demonstrate what Mr. Marsh intended this comment to mean, do we? Because your counsel, ORS's lawyer, asked Mr. Marsh about this very email during his deposition 1 week ago today. Do you know that?
No, I do not know that.
Okay, we only have the rough draft of Mr. Marsh's deposition transcript, but let's throw that up on the screen if we can. This is page 149.
Mr. Chairman, objection. Foundation is not reviewed.
Could you get your microphone again, please, sir, and say that?
Yes, Mr. Butler, my apologies. Jim Cox again from the White firm appearing on behalf of ORS. ORS would object for lack of foundation. The witness has not reviewed this deposition transcript.
I think we should allow that. I think you have a right to impeach him with materials such as this, even though he may not have had a chance to review it. I think he can at least ask him about it, and the witness can answer as best he can.
Thank you, Mr. Butler.
Thank you, Mr. Butler. Okay, line 1. Question by Mr. Cox, ORS's lawyer.
I'm sorry, are you going to provide me with a copy? I
We have it
can't
on
see that.
screen. We do have a copy if you would like it.
Yes, I would. I can't see that.
He's going to blow it up. That question and answer, Dan.
Okay, now I can see it.
Okay, so the question is on bullet point number 3, and if you look at the email that we had previously identified, bullet point number 3 is in Mr. Marsh's email to Mr. Carter. Mr. Cox asked Mr. Marsh to read that sentence. Then he read the very first sentence, and then we'll continue in Mr. Marsh's deposition transcript. So after reading the very first sentence, Mr. Cox asked, give Dan a second to continue. Pull up the rest of the page, probably be good. Okay. Mr. Cox asked Mr. Marsh, that was a true statement at the time you made it, right? Some objections. That was the statement I made at the date of this email. Then Mr. Cox asks, and is it true that ultimately your company authorized the retention of the Bechtel Corporation to conduct this assessment? 2 objections, and then this witness. What does it say? Mr. Jones?
Why, do you want me to read it?
Yes, Mr. Marsh's testimony on the very same paragraph you're relying on to say that the owners agreed to hire Bechtel in September of 2014.
No, that's not correct.
That's what Mr. Marsh said. It is not correct. This email does not signify the owner's agreement to hire an outside resource in September of 2014. And then, were there any doubt? Mr. Cox asked, tell me how that's incorrect. The very last question on this page. The very beginning of the next page of the transcript. Mr. Marsh answers. He says, this was not in any way referring to Bechtel. So the only document you have to show that the owners believed and agreed to hire an outside consultant in September of 2014 is an email that on its face is talking about hiring an employee to be on the owner's staff, not an outside consultant. And the testimony on this document is unequivocal. It is not in any way referring to Bechtel. Is it still your belief that the owners agreed in September 2014 to hire an outside consultant to conduct an assessment of the project?
I would say, based on my knowledge that who was hired, I don't think anyone was hired, and they subsequently hired Bechtel. I think that was the ultimate outcome of this, that Bechtel was hired as a consultant.
Bechtel was hired in August of 2015, right?
There's other discussions of Bechtel, like the submittal of a proposal and things like that. So
First meeting,
ultimately, they did hire them in August. They did retain them in August, but there were a lot of discussions prior to that.
and the difference between September 2014 and August in 2015 is pretty critical in this case, isn't it?
No,
Because the ORS believes that all costs incurred prior to March 12, 2015 should be disallowed. So March 12, 2015 is the magic date here, isn't it?
I don't understand why you're maintaining that there was no discussion of Bechtel before this date. The retention of Bechtel is not key in this case. In my mind, the key is the intention to hire them.
In the first meeting between, we talked about this on Friday, the first meeting between SCENG and Bechtel was in April of 2015, wasn't it?
That is correct, but that is the time shortly after the filing, and the fact that it's relevant to the filing and was intended to be done prior to the filing, I think has absolute relevance to that date.
You have no basis for contending that there was any agreement to hire Bechtel prior to the filing. The only thing we've seen is the September 3, 2014 email. Right?
I have every basis to contend that they intended to hire Bechtel during the time that the filing was in place, and they could have been notified to the commission that they were intending to do so. That would have affected the review of the filing, and that is the date that I believe that is of substance here, is when the intention to bring Bechtel in to do the review and what was pending before the PSC, and that was the March 12, 2015 filing.
Other than the preliminary proposal provided to the owners in February, please identify for the commission a single document that signifies the owner's intent to hire an independent consultant to do an assessment of the project prior to March 2015.
I believe there was a meeting prior to that. I think it was a so-called hangar meeting. I think that was in, I'd also have to look at my chart again to get the date, but there was a meeting with Bechtel prior to them submitting the proposal, Bechtel, Santee Cooper, and SCE&G. I think it took place in the airplane hangar, so that was another date prior to the Bechtel submittal of the proposal.
So you had a meeting and a proposal, and that's it. Nothing else that you've seen that indicates the owner's intent to hire Bechtel prior to March 12, 2015, right?
I'm sorry, what else do you want me to have, sir?
Well, we know, do we not, that Bechtel was actually hired in August. And then we also know that within weeks of that, Gene Sult was informed that SCE&G's legal department had engaged an outside consultant. Within weeks of that, Mr. Jones. And then within 2 months of that, you knew, Mr. Sult knew, that ORS had conducted an assessment. But the whole basis for the ORS's position in this case is that March 12, 2015, all costs from that time should be disallowed.
That is correct.
Even though Bechtel was engaged in August, the ORS was informed within weeks that the legal department had engaged an outside consultant, and then within 2 months, you and Mr. Sult were aware of the fact that Bechtel had conducted an assessment.
Mr. Chairman, ORS would object. Questions are argumentative and badgering the witness.
Mr. Chairman, if I may, Mr. Jones has indicated that he believes his trust was breached. He has claimed that SCE&G employees failed to describe to him the circumstances surrounding the Bechtel engagement, and it is not true. So I believe Mr. Jones should be required to answer those questions.
Okay, sir, I think Mr. Jones is entitled to one more answer, but I believe that's enough questions on that subject. So, Mr. Jones.
Would you repeat the question, please?
So you knew, Mr. Jones, that Bechtel was hired in August of 2015, that within weeks of that, Gene Sult was informed that the legal department at SCE&G had engaged an outside consultant. And then within 2 months of that, you and Mr. Sult knew that Bechtel had conducted an assessment on the project.
Wow, you put a lot into that question. First off, I did not know that Bechtel was engaged on August 15th. I did not know the date of the engagement. Second, I did not know that they were hired by attorneys. Third, I did not know, or at least I do not recall Mr. Sult indicating to me in August that there was an assessment underway. As I've testified, my first knowledge of that in my memory is after Mr. Salt reported after the October 15th POD meeting. And as I've testified at least 20 times, we did not know the scope, the extent, the results, or any of the details of the assessment that had been made, and were told there was no written report. And that's where I believe the deception came in. The fact that the indication that there was no written report when in fact there were weekly summaries available that would have indicated what was going on.
Mr. Jones, you were told about the Bechtel assessment in October 2015, and the SCE&G employees you talked to told you that they didn't believe there was anything new from the Bechtel assessment. Isn't that right?
Correct.
Have you read the deposition transcripts of SCE?
Mr. Shalley, excuse me, I think we'd ask you to move on. I understand your desire to continue, but I think he answered the question.
Okay. I am moving on to a different topic, Mr. Butler. Thank you. Have you read the deposition transcripts of SCE&G executives managing the project and whether they, even to this day, continue to believe that Bechtel identified nothing new?
I mean, you'd have to be more specific in that question.
Okay. Have you read Ron Jones's deposition transcript in this case?
I recollect, deposition. No, I did not believe I've read his deposition. I think I read testimony, but I don't think I've read his deposition.
Okay. You do understand that Ron Jones was an executive higher up the chain at SCE&G than the people you talked to about the project. Isn't that right?
I do.
Okay. And he was ultimately leading SCE&G's construction team on the site, wasn't he?
I think that would be part of his responsibilities, yes.
Okay. I'd like to show you what Mr. Jones testified to about the Bechtel report. This is a transcript of Mr. Jones's deposition. I'm going to go to page 206.
Mr.
Dan?
Chairman, I've got an objection to this line of questioning. The witness says he hasn't seen Mr. Jones's deposition. So what counsel is now going to do is going to publish into the record portions of Mr. Jones's deposition, Ron Jones's deposition. That's inappropriate. That's not cross-examination. That's just introducing testimony that they prefer.
Mr. Butler, as I said at the conclusion of Mr. Jones's summary in this case, he's identified snippets of evidence, and he contends that based on those snippets, there was wrongdoing here. It's incumbent in light of that opinion to show him the full story, which we believe is conveyed through the deposition transcripts that I'm going to describe to him, and confirm that there was no deception.
Okay, we're going to overrule that objection.
So we're going to look at page 206, line 14, to Mr. Jones's transcript. In response to a question related to the Bechtel report, Mr. Jones says, well, again, for a number of the observations...
Mr. Chairman, I just object. Could we have the question read? The witness is answering just for the completeness of the record.
Fair enough.
Question was, sitting here today, do you recall what steps SCE&G took to implement the conclusions from the Bechtel project assessment? Following my objection, Mr. Jones begins to answer. He says, well, again, for a number of the observations, conclusions, whatever they had, there was really no action required because it was either something already ongoing or it had been negated by Westinghouse purchasing Stone & Webster from CBI, that sort of thing. The other comment I would make on their recommendations and observations is they came in over a 6 or 7 week period, and the majority of what was in the report was known to us already. The term I use is they came in and circled the bullet holes. They really didn't provide any. Here's what you need to do different. So in my opinion, report provided little value to us.
We need to get the rest of that, what you're reading up.
Sorry, I went too fast. So Mr. Jones made clear in this deposition, Mr. Gary Jones, that in his opinion, the report provided little value to SCE&G, right?
That's what was stated, but I would disagree with that.
But that's what you were told by SCE&G employees that you talked to in October 2015. There was nothing new from the Bechtel assessment.
Nothing new from the Bechtel assessment.
Consistent with what Mr. Jones has testified to under oath in this proceeding.
I think the way I would respond to that is if there was nothing of value, why did they track the implementation of the Bechtel recommendations on a separate report, which was also withheld from ORS? If there was nothing of value, what was the purpose of that? I would also point out that all of the supposed recommendations or programs that he says were implemented, if they were implemented, the programs that were not brought to the attention of ORS until after January 2016. When these programs started to be developed we were under the impression at the time that SCE&G had finally started to take action that would resolve some of the issues on the project. And we were very pleased to see that they were implementing some of these changes. But all the ones we were aware of, except for the implementation of the project management office, which started almost contemporaneously with the time of the Bechtel, first Bechtel presentation, that the operation of the project management office started before that, but that's the only one that we were aware of prior to January 2016, when we thought that Fluor had come in and worked with SCE&G, and we were finally seeing some positive results come about on the project.
Okay, Mr. Jones. But what Mr. Ron Jones is saying in his deposition testimony is consistent with what you were told in October 2015 regarding the Bechtel assessment. There was nothing new learned, right?
That's what his testimony says, and that's what I was told.
Have you read the second day of Steve Burns' deposition transcript in this proceeding?
Again, I don't think I've read any of the depositions. I've read testimony, but not the depositions. I think the depositions were fairly recent.
So your opinion in this proceeding is based on information that doesn't even include the deposition testimony on the very subjects you're discussing. Is that right?
I would have to say yes, because they're very recent, and I'm sorry I haven't had time to read them.
Okay, let's look at what Mr. Byrne testified to regarding the significance of Bechtel's 7-week review. This is Mr. Byrne's deposition, page 134.
Mr. Chairman, just for the record, ORS again objects to this testimony being read into the record.
We're going to let him go ahead.
Getting it up on the screen. Okay, we're on page 134, Dan. Line 17. And we're going to go through to 135, line 5. I'll just let you blow that up. Is this? I think this might have been day 1. Sorry.
We got a written copy we can show him if this is going to take. We're having a.
We do not. I can read the quote. We're happy to do that.
Yeah, I'd rather see it.
Yeah, I agree.
You have something else we can move on to while we're getting situated, or is this?
We can. I will. We can do that. I was also going to show Mr. Jones, following Mr. Burns' deposition, additional language from Mr. Marsh's deposition, and then language from Mr. Winnick's deposition. I'll let our team get on to that, unless they are going to give me a thumbs up saying they've got it. So no. You have Marsh? Okay, we'll do Marsh. The rough at page 256. Mr. Marsh was asked about the significance of the Bechtel assessment. Have you read the rough transcript of Mr. Marsh's deposition conducted a week ago, Mr. Jones?
No, sir, I have not.
Okay. Page 256, line 8 through 15, Dan. Okay, so this is Mr. Marsh's. I'll read the question that immediately precedes this. The information regarding the schedule assessment by Bechtel on page 24 of this document, SCE&G never provided that information to the commission, correct? Mr. Marsh responds, I don't recall providing that information. As I stated, this was a preliminary assessment. There were certainly discussions in the meeting regarding the accuracy and completeness of the information. I recall that very robust discussion, so in my mind, these were not dates that we had concluded, and we continue, were accurate or that could be relied upon. That's what Mr. Marsh said about the Bechtel assessment. You never read that, right, Mr. Jones?
No, I never read that.
Okay. He continues, and then page 260 of his deposition transcript, Dan? Lines 1 through 24. What it says here, the question is, were you, Mr. Marsh, upset that you hadn't been informed that Bechtel had issued a schedule assessment report earlier? Mr. Marsh responds, no, I wasn't upset. I had been informed by my legal counsel, outside legal counsel, that the report was not fully developed enough to be relied upon, so I was not surprised that I didn't get a report. That's what Mr. Marsh said about the Bechtel schedule assessment.
Mr. Chairman, Robert Guile for Friends of the Earth Sierra Club. We'd object to what appears to be counsel's use of these documents, not to impeach. He's established that the witness hasn't read them. That's not significant, but that's all he's gotten. I just fear that in a proposed order, we're going to have SCE&G citing these excerpts as proof of the matters asserted without offering these people as witnesses or the depositions in full. So I think it's proper to try to impeach a witness from anything, including an excerpt of a deposition, but that excerpt is not admitted for proof of the truth of the matters asserted. And I'd ask the chair to so rule so that we don't see these excerpts popping up in a proposed order as substantive evidence.
Agreed, and I'll sustain that, Mr. Guile.
Okay, then do we have easy access to George Winnick's deposition transcript? We're going to go to page 74. Mr. Jones, you do know who George Winnick is, right?
Yes.
The outside lawyer that actually engaged Bechtel in August of 2015, isn't that right?
The agreement was signed through Mr. Winnick's office, yes.
Okay. On page 74, line 15, Mr. Winnick is asked, is it fair to say that the senior management of the owners were not happy with the results of the Bechtel assessment? Mr. Winnick responds, I remember that they thought it was pretty thin gruel. That is that some of their comments and findings were delivered as though they were the first time any issues had been identified, whereas it was pointed out to me that a number of the issues they were looking at were the subject of frequent meetings between the owners, and this says Bechtel. So then he continues, start on 25 and continue to the next page, Dan. Right. So there was one category that was obvious. One category of the Bechtel assessment that was obvious. And then he says on the next page, there was another category that was mooted by the October 2015 amendment, which was already in final form at the time of Bechtel's oral presentation. And there was a third category where they were doing things with an unreliable methodology that was considered to be useless. That's Mr. Winnick's testimony. But you haven't read Mr. Winnick's deposition, have you, Mr. Jones?
I have not, but I totally disagree with it, and I don't understand what qualifications he has to make such statements.
Well, he's the one who engaged Bechtel.
That has nothing to do with him having knowledge about how schedules are done.
In any event, the testimony of SCE&G executives and the lawyer that hired Bechtel is pretty consistent with what you were told in October 2015.
I disagree with almost all the points in this.
And that the Bechtel assessment identified nothing new. It's the same thing you were told in October 2015, and it's the same thing these SCE&G executives and SCE&G's outside lawyer had concluded at that time, right?
That's what they concluded, and I believe it is erroneous. I also believe that SCE&G had no right to unilaterally decide what should be shown to us and what should not be shown to us.
Right. So on that point, the only written request that you had identified to require the disclosure of the Bechtel report was AIR 132. Isn't that right?
That is correct, and we've been through this many times before.
We have, but there are two additional points that I want to make sure the Commission is aware of. You contend that AIR 132 covered the Bechtel assessment, right?
I contend that it should have covered it, and it should have stated they should have at least listed Bechtel.
And you believe that the AIR was broader, sought information broader than consultants hired under the EPC amendment. Isn't that right?
Yes, I do.
Right. And it has to be broader than that. It has to be broader than consultants hired under the EPC amendment, because you know that Bechtel wasn't hired under the EPC amendment.
I don't really think it has to be broader because the EPC amendment also includes the original contract. There's parts of the amendment that adopt the parts of the original contract. So it's still there. It doesn't go away just because there's an amendment to the contract.
Have you read Alan Powell's deposition testimony in this case?
Again, I have not because it was recent.
Would it surprise you to hear that Ms. Powell believed that the AIR 132 was limited to consultants hired under the amendment, not the agreement?
Wouldn't surprise me, but again, that is a broad spectrum because, again, it includes the original contract.
Okay. I'd like to show you the transcript from Ms. Powell's deposition, which was conducted recently. October 26th is the date I've got. I'm going to go to page 137. Or I think it's 137.
Hey, Mr. Challey, we're sort of going round and round here on the same thing. So if you're getting close, that would be.
I am. I think the one point that I'll make clear, let me, if I can, just to sort of make sure the record is in, I want to make sure Mr. Jones wasn't familiar with this testimony. If I just want to read a brief exchange from Ms. Powell's deposition that perhaps if we can get it on the screen, we will, but I'll otherwise read it.
Okay.
And I do have a copy of it, so I'm happy to tender this or a copy of the excerpt.
ORS would renew its objection, Mr. Chairman.
Okay. All right. I think he's entitled to read it, so let's have it.
Thank you, Mr. Chairman. This is from Ms. Powell's rough transcript, and I believe we are on page 137 of it. Question is, Ms. Powell, you have just been handed what has been marked Exhibit 10 to your deposition. I'll represent to the Commission that Exhibit 10 is the AIR request that we've already seen. Do you recognize this document? Ms. Powell responded with yes. Okay. And is this the interrogatory you referred to earlier today? She says, I believe so. Yes. So if you read the title of this document, it states that it is South Carolina Electric and Gas Company, Office of Regulatory Staff's first audit information request, October 15 amendments to the engineering, procurement, and construction contract related to the construction of a nuclear baseload generation facility at Jenkinsville, South Carolina. Do you see that? She says yes. So these are requests that were submitted about the October 15 EPC amendments, right? Yes. And the request, 132, the first sentence states, has SCE&G decided to retain the services of a project consultant as allowed in the agreement? Do you see that? Ms. Powell says yes. And then the question, and you understand that to be a reference to the EPC amendment agreement as reflected in the overall purpose of the request? She says yes. So Ms. Powell believed, as she testified in her deposition, that AIR 132 was limited to the EPC amendment. Have you seen that testimony, Mr. Jones?
I would again emphasize that the amendment does not preclude content of the original agreement. And in fact, if you read the first sentence of the question, it says the agreement, not the amendment. Granted, the title says that, but that's what we were asking the questions. This is what prompted the AIRs is the issuance of the amendment.
Okay, so
but the question says, as allowed in the agreement, and in the amendment, there is no mention of allowing someone to be hired as a project consultant. It is in fact in the original agreement.
Okay, Mr. Jones, so after you got SCE&G's responses to this AIR, you and Ms. Powell worked on a letter to request additional information in response to this interrogatory, didn't you?
We submitted a supplemental question, yes.
Okay, so can we put tab 19 on the screen, Dan? So he had to reboot. So we have copies of this one. Have you seen this document before, Mr. Jones?
Yes.
In fact, it's a document that you produced in this case, right?
Well, the first part is, yes.
Well, I believe if you look at the top right, the header identifies GJ emails, 2016 volume 1, and then it continues. And that Bates label is on every page of the document, right?
Yes, these are my suggested edits to the document prepared by Ms. Powell.
And this document came from your files, is that right?
I have no idea where it came from.
So the Bates number at the top right doesn't
Means
indicate.
absolutely nothing to me.
Okay. Do you have any reason to dispute the authenticity of this document?
No, I do not.
All right. I'd like to move for admission of this document as the next hearing exhibit, Mr. Chairman.
Okay, this document will be hearing exhibit number 24.
Okay. So, Mr. Jones, this is an exchange between you and Ms. Powell where you're talking about sending a letter to SCE&G about the responses to the AIR requests. Isn't that right?
This was ARRs in general, not just the specific one you're talking about.
That's right. So, but it encompassed the set that included 132, did it not?
Yes.
And you didn't mention 132 in here at all, did you?
Don't believe so.
Nope. And you knew at this time that Bechtel had conducted an assessment, but you didn't say one word about supplementing AIR 132 to reflect additional information related to the assessment, did you?
No, I did not. And as I've said before, there were much bigger fish to fry at the time that the amendment came out than trying to find out something about a report that supposedly had nothing new, no, never mind.
Right. At the time, you didn't think there was anything significant associated with the Bechtel assessment, and it's only after now that you've concluded, after abandonment now, that you've concluded that Bechtel is somehow more significant, right?
Yes, sir, because I saw it.
Okay. In any event, you would agree with me, would you not, that the draft letter makes clear, the very first paragraph of this letter makes clear that the ORS understood AIR 132 to be limited to the amendment, correct?
What are you talking about?
The page is at the top, GJ Emails 2016, Volume 1, 002200. You see that? It says, Dear Mr. Marsh,
Yes, okay.
ORS has completed its initial review of SCE&G's responses to the request for records and information, parentheses, AIR, that was issued on March 4, 2015, regarding the October 2015 amendment, right?
Yes, as I've indicated before, the primary purpose of these AIRs was to address the amendment.
Okay. And you didn't think you needed to ask for more information related to Bechtel because you didn't think Bechtel was significant at the time, correct?
Yes.
And that's a conclusion that, as we've seen, Mr. Marsh, Mr. Jones, Mr. Winnick agreed with then and agree with now, right?
Well, it's just amazing to me that if you didn't believe it was significant, SC&G took so much pains to hide it from us, that they scrubbed it, they whitewashed it, and they flushed it. So, yeah, I didn't believe it was significant at the time, sir, because that's what I was told.
And the basis for
and I think that's a consistent and constant position that I've held throughout my testimony. I still maintain it, and regardless of how many examples you're going to bring up, you're not going to change my opinion.
So one final question on Bechtel, and then we'll move on to Mr. Jones. The only request you made for more information related to the Bechtel assessment, and as a result, the entire basis for you contending that we withheld, that SCE&G withheld or failed to disclose information related to the Bechtel assessment is AIR 132. That's it, right?
For what must be the 15th time, yes.
Okay. Now let's move on from Bechtel. Beyond Bechtel, you claim that ORS should have received additional information regarding the schedule for the project. Isn't that right?
We should have received additional information for the schedule and for the cost, yes.
So as to schedule, you were aware, were you not, that there were risks associated with the schedule that was submitted for approval in 2015. Isn't that right?
Yes.
And you're aware of that from Mr. Burns' pre-filed testimony in 2015, correct?
That's one of the sources.
Okay. Because Mr. Byrne made very clear that there was a risk to the schedule in 2015, right?
He did.
Okay. In fact, he said, did he not, that the schedules can and almost certainly will change, correct?
Correct.
So there was a risk to the schedule that was disclosed to you and disclosed to the Commission by Mr. Byrne in his pre-filed testimony.
Yes, and we were aware of risk to the schedule.
Okay. I believe this might have been presented to you right as we broke on Friday, but you drafted testimony in 2015 to submit to the Public Service Commission before the settlement between the ORS and SCE&G was entered in that docket, right?
Yes, I did.
Okay. And in that testimony, which is tab 15, and I think we are live. Good. I want to make sure you have a copy of this, Mr. Jones. You've seen this document before, haven't you?
Yes.
In fact, it's a... Oh, sure. I believe this is a document that I showed you during your deposition. Isn't that right, Mr. Jones?
I believe it to be so, yes.
And this is draft testimony that you prepared in 2015, correct?
Yes.
Okay. Did you personally prepared this testimony?
I did.
You were familiar with its contents at the time you prepared it?
Yes.
Okay. Mr. Chairman, I'd like to move for admission of this document as the next hearing exhibit.
Okay. Mr. Jones' direct testimony exhibit will be hearing exhibit number 25.
Mr. Chairman, just to clarify for the record, this exhibit is draft testimony. I don't believe it was ever submitted to the Commission.
That is correct. It was not.
Can you clear that up for us, Mr. Jones? Why was this not submitted to the Commission?
My understanding was once the settlement agreement was reached, the only testimony that we were going to file had to do with the testimony associated with the settlement agreement. So the settlement agreement was made before this testimony was filed, and the decision was made that the ORS testimony would address only the settlement agreement.
But it accurately reflects your knowledge regarding the project as of the time of the testimony. Isn't that right?
It does reflect, yes, my knowledge at the time of the testimony, yes.
You made clear in 2015 that you had concerns in your review of the proposed project schedule, right? This is on page 11, the bottom of page 11. It's the question that you presented.
Yes.
What concerns?
Yes.
And then you continue for a number of pages to describe those concerns, don't you?
Right.
So these are all concerns that you knew to exist. Even though you say you didn't have information regarding the Bechtel assessment, you knew all these concerns to exist in 2015, right? Okay.
I will calmly repeat what I have maintained throughout. We were aware of most of the issues identified in the Bechtel assessment. We were not aware of the schedule assessment. We were not aware that Bechtel made recommendations that in fact were going to be implemented on the project and tracked through the project. I've never denied that we knew most of the issues. I think you if you had any association with the project, you knew the issues. The issues is not the question. It's what the recommendations for resolving the issues were in the schedule assessment that I consider the primary failures to disclose by SCNG.
But you yourself knew of the problems in the schedule, even though you claim you didn't know about the assessment, right?
I don't claim I didn't know about the assessment, sir. I did not know about the assessment, at least the scope, the extent, the issues, the resolution, the issues identified in the schedule assessment. It's not a claim, it's a fact.
Because you didn't think more information related to the Bechtel assessment was significant.
I was told that the information was not significant.
Okay.
We've
now,
done this, we've asked this question about 20 times now, so.
All right, Mr. Chairman, I'll move on.
We get it.
I'll move on. Now, you yourself didn't develop a schedule for the project, right, Mr. Jones?
No, sir, I did not, and nor was that part of my responsibilities.
Yeah, you said during your deposition that you didn't think it was your job to develop a schedule, right?
It is not my job.
You are familiar, are you not, with scheduling efforts related to nuclear construction projects, right?
I am.
And you agree with me that preparing a schedule is a very complicated task, right?
If you're talking about a complete construction schedule that you're going to use to build the plant, yes, it's a very complicated task.
And it's very time-consuming, is it not?
It is.
Okay. We talked in your deposition about how costly it would be to create a schedule for actually managing the construction of a nuclear reactor, right?
We did, and we also talked about the fact that that's not what Bechtel did. Bechtel did not create a schedule to manage the project.
Yeah, there's no dispute as to that. Bechtel didn't do the assessment that would be required to actually create a schedule that would manage the construction of the project, right?
They did not, and that was not what they were charged with.
Right. And nor did you do that.
No, I did not.
So the only entity that you know of that actually did that work was Westinghouse, right?
If you're talking about Westinghouse in the context of being the consortium, the actual schedules were mostly produced by their construction contractor.
Okay, but it was the consortium that did the schedule work, right?
Yes.
Okay, and by 2014, you knew that Westinghouse would have had to have invested millions of dollars in the preparation of a schedule, right?
I would have assumed that. Knowing is different, but to get to where they were with what I had seen in the schedule, it would appear that they have spent a lot of money doing that, yes.
And part of the basis for your assumption is that you told me that just preparing a first cut at a schedule for a project of this sort would take somewhere between 3 to 6 months and would cost somewhere between at least $500,000 to $1 million.
That's what I said in my testimony.
That's just
my
a
deposition. I'm sorry. Yes, sir.
So that's just a first cut. And you knew that Westinghouse, beyond the first cut, had been working on the schedule for years, right?
Yes.
Okay. So you knew that Westinghouse had dozens of people working on the project schedule, isn't that right?
Yes.
And you knew that for the 2014 schedule that Westinghouse presented, they had been working on that schedule for months, correct?
I did not know that. I mean, I assumed that. I did not know that. I know that the schedule that was touted that this was going to be a brand new, fully integrated. At that time, the resource loaded was not in there, but this was going to be a new, fully integrated schedule that would reflect new construction dates for the project.
In your summary of your testimony that you read before the commission, you indicated on page 10 that the schedule of a nuclear power plant is very complex and comprised of thousands of interrelated and interdependent activities, right?
Yes, sir.
And I think you told me on Friday that you understood the schedule for this project to contain somewhere in the neighborhood of 500,000 independent interrelated activities, right?
That's correct.
And that was more than double of the amount of activities that you had seen in any project in your career.
Yes, that's pretty much true, yes.
And you knew that the only entity that had gone to the trouble of evaluating and developing a schedule of that detail was the consortium.
Had gone to the trouble. That was their job. I don't know what you mean by gone to the trouble, but
They're the only entity that did that work, right?
that's my understanding, yes.
You didn't do that, and Bechtel didn't do that.
Correct.
Okay, Mr. Jones, you always say that, you also say that with respect to SCE&G's 2015 filing, you believe that ORS should have received additional information regarding SCE&G's cost estimate calculations. Isn't that right?
Yes.
Okay. But you had extensive information regarding these cost calculations, didn't you?
Extensive information. What I didn't have was the EAC result, if that's what you're talking about.
Well, you were certainly aware of the fact that SCE&G had received an updated estimate at completion from the consortium in August of 2014. Isn't that right?
That was the date that it was supposed to happen. At the time, we didn't know for sure that they had, but that was the date that it was supposed to happen.
You ultimately got a copy of that estimate at completion presentation, didn't you?
We did have a presentation on the estimate of completion based on the consortium results, not based on the EAC team results.
Let's look at tab 16, Dan. This is another document related to a separate audit information request, right?
That's what it says.
Did you receive this document at the time that it was created in April of 2015?
I believe I did so, yes.
So you're familiar with this document?
I wouldn't say I'm familiar with it. I have seen it before. I haven't looked at it in more than a couple of years. But
Any reason to dispute its authenticity?
I have no reason at this time, no.
Okay, Mr. Chairman, I'd like to move for admission of this document.
Okay, this will be entered as number 26.
Mr. Jones, you would agree with me, would you not, that in this response, SCE&G provided to the ORS the very same estimate completion presentation that Westinghouse had provided to SCE&G. Isn't that right?
That's what's stated, yes.
And it reveals the substance of the estimate at completion that the consortium had prepared, as well as its assumptions, does it not?
That's so stated.
Can you flip with me to page 28? So this is information that you would have had no later than April of 2015, correct?
Okay.
And the presentation was provided in August of 2014, isn't that right? The date on the first page of the presentation?
That's so stated.
Okay. So at that time, Westinghouse had made clear to SCE&G, and SCE&G had later made clear to the ORS that the estimated completion was based on a series of assumptions, correct?
Correct.
It also made clear that the current PF, which you understand to be productivity factor, don't you,
Yes.
was 1.41, right?
Yes.
Okay. And then the estimate at completion that Westinghouse was providing was based on several factors, correct?
Yes.
And specifically in the very last bullet, the ETC PF of 1.15 to be realized through gradual improvements over 6-month period. See that?
Yes.
Okay. So you knew the time you received this presentation that the current productivity factor was in excess of 1.4. You further knew that the estimated completion Westinghouse had provided was based on a performance factor of 1.15 that was to be achieved within 6 months of the August presentation, correct?
Yes.
Okay.
And I actually believed them at this time.
Well, you knew in April of 2015 that 6-month improvement hadn't materialized, didn't you?
We were aware of what the productivity factors were at that time, yes.
The productivity factor hadn't gotten down to 1.15, correct?
I think it's very interesting that all this burden supposedly is coming on me.
It's not, Mr. Jones. I'm simply saying you didn't believe you needed to point out to the Commission the same facts that you and SCE&G knew, which was that the estimated completion in 2014 was based on a performance factor of 1.15, which was lower than the historical PF, was lower than the consortium was able to achieve in the 6 months that they had promised. You didn't tell the Commission that. You didn't believe you needed to tell the Commission that, right?
I didn't normally report to the Commission on productivity factors, no.
And you didn't tell the Commission in 2015 that you didn't think the cost estimates SCE&G were relying on in 2015 were unreliable.
At that time, I actually thought that they were, and I said I thought that they were. I thought that the plant could be completed at that time within the 18-month windows. I thought there were going to be productivity improvements, and I thought that SCE&G had taken the initiative to do that. Now, at the time you're talking about, later, confidence was beginning to erode, but I still thought they had a chance of doing it. What I didn't know is that SCE&G had no confidence in the ability to do that. And I would maintain that the primary responsibility to tell the PSC that was SCE&G's.
Okay, well, let's look what you asked SCE&G to provide additional information on in May of 2015. This is tab 17, Dan. You're familiar with this document, aren't you, Mr. Jones?
Yes.
This is yet another follow-up to an audit information request from the 2015 docket, right?
Yes.
And it's dated May 22, 2015. And in fact, you sent it to SCE&G, isn't that right?
Yes.
Okay. So do you have any reason to dispute the authenticity of the particular document I've handed to you?
No.
Okay. I'd like to move for admission of this document, Mr. Chairman.
This document will be entered as exhibit number 27.
So you asked SCE&G to explain how it accepted a productivity factor as the basis of the EAC that reflects a significantly higher level of productivity than has yet to be realized during the previous several months of high levels of construction activity, right?
Yes.
And then SCE&G responded and described the basis for its reliance on a 1.15 productivity factor, right?
Yes.
And it said on the last page of this document, in response, in their revised EAC forecasts and revised milestone schedule, the consortium represented that it will improve the productivity factor from current levels to 1.15. And it continues, based upon frank discussions with the consortium about achieving the improved productivity factor, based upon productivity factors achieved to date on units 2 and 3, SCE&G has had frank discussions with the consortium about achieving the improved productivity factor of 115. And then the company makes clear its basis for relying on the productivity factor and estimates that Westinghouse had provided. The company believes that it would be speculative to use a different productivity factor and further does not believe it is appropriate or in the best interest of SCE&G and its customers to suggest to the consortium that it should not make every effort to meet its commitment to improve labor productivity. See that?
Yes.
So that's why SCE&G relied on Westinghouse's estimated completion as opposed to some other number, right?
That's what's stated.
Even though you knew, and even though SCE&G knew, that historical performance was not as productive as that assumption.
Yes.
You didn't think you needed to tell the commission more information related to that historical productivity or more information related to concerns as to whether the consortium would meet its promised productivity factor, did you?
I did not. I did not believe so at the time, no.
And you understood that Mr. Byrne testified to the commission in 2015 in very similar terms to this response to the audit information request, correct?
I don't follow that question.
Mr. Byrne testified in 2015 that as to both timing and cost, the schedules are based on productivity factors WEC/CB&I represents can be met given the current status of the project. And then he says, meeting those productivity factors will pose a challenge to WEC and CB&I. And he concludes with, SCE&G does recognize that WEC/CB&I has set itself a significant challenge to future productivity. Isn't that right?
That's what's stated. What's also stated in documents that we didn't see is that SCE&G didn't think that the productivity factors were challenging. They thought they were unachievable.
All right, we'll get to that in a minute.
Mr. Challey, let's hold that thought. We're going to take a break.
Thank you, sir.
10 minutes.